Yeah, try to do it like that. And give the dual feeling of participation. All right. Yeah. Give the dual feeling of participation.
There's a little bit of a backline.
I know, that's right. Oh. Let's go this, and then that one. Oh. Sharing, that's what I want to share. I want. The power. Does everybody on the? Yes, I'm allowed. Does everybody on the Zoom hear us clear? Put a thumbs up if you do hear us before we begin the session.
Good evening, everyone. Yes, Jill, clear.
Oh, wonderful. Thank you.
So apology for the little hiccup. We had some technical challenges, but we're here. We're gonna get started.
That's fine. It's quite understandable.
Sure.
No, we're gonna get started. Because we're running a few minutes late and we want to be considerate of your time. We're going to just get started. My name is Regine Francois Williams. I'm a licensed attorney in Maryland, DC, and Florida, and I am joined today by with Vanessa Abdelrazak, who is an advocate from IET. Vanessa, do you want to introduce yourself just briefly?
Yes, so as Regine said, I'm an attorney in Haiti. My name is Vanessa Abdelrazak. I mostly practice corporate and business law, intellectual property, and assets management. It's a pleasure to be here with you today.
All right, thank you so much. Well, we're gonna get started. Thank you so much to the Association of Haitian Professionals for inviting us this evening. And so we're gonna get started. First, we'll do the disclaimers. Remember, this is a presentation for informational purposes only. I always recommend that if you are in the process of planning or considering planning, that you seek the advice of your own counsel, okay, whether that's a tax counsel or otherwise. We're super excited to share the information with you all this evening, and thank you so much for giving us a little bit of your time. Okay, so we're gonna jump right into it, okay? What is estate planning? And our format for this evening is, I wanna say kind of like a yo-yo, right? So I'll tell you the presentation or the information from the American system, primarily because I'm licensed in, because I'm licensed here, I'm licensed in Maryland, the District of Columbia, in Florida. So that's gonna be the basis for the information. And then Vanessa is going to share the information from Haiti. So kind of a compare and contrast so you can see how the systems are different, but also really emphasize for you the importance of planning, okay? So what is estate planning? I say estate planning is a roadmap. It tells us what you want to happen in your life while you're living or after you're no longer here with respect to your body and or your assets, okay? And so tonight we're going to be talking about this roadmap and what it includes, okay? It's really important that when we're talking about estate planning, we're not just talking about death planning. Yes, that's part of it. And a lot of people come to us when they think there's going to be death or when they feel that there's going to be death or something close to it. But we're really going to be talking also about planning for your life and your livelihood, so your personhood. I welcome any questions during the presentation. We may take the questions at the end, but if questions are relevant, we do have a co-host, Gilles Charleston. So Gilles, if you see something that's pertinent to what we're asking, please feel free to chime in, okay?
Will do.
Okay, thank you. So who needs an estate plan? Everyone. It's like the Oprah. Remember back then, you get a car, you get a car, you get a car. This is literally, you get an estate plan, you get an estate plan, you get an estate plan. Everyone needs an estate plan. Because if you don't choose to make a plan for yourself, if you don't choose how you want to be treated in terms of your body while you're living, if you are sick, incapacitated, if you have dementia or any other, life transitions that may happen to you, or if you don't choose who's going to be able to manage your finances, if you need it, then the government has a plan. The government's plan is more costly. The government's plan may not be what you choose to have. And in the US, it's called intestate, right? So generally, intestate means when you die without a will, okay? And so, Vanessa, if you'll go over the concepts.
Yes, sure. So the concept, the concept that you just mentioned, is the same in Haiti, which we call it ab intesta. In Haiti, Haitians barely speak about planning after death. I think it's a cultural thing. But if you die and you don't have a testament, a will, in Haiti, we call that dévolution successorale. So the law will establish who your assets will go to. So definitely, just like you said, Regine, it's always best to plan ahead. And as it is with Haitian law, we don't have the same mechanisms and tools, but there are ways to plan ahead and ensure that the assets go to the right persons, and that the person after death, their wish are respected.
And since you're here today, I would say that you don't want to have an intestate estate, an estate without proper planning, or an estate ab intesta, right? And so we're going to be talking about all of these: planning for death, healthcare planning, property management planning, wills and probate. We'll do a little bit of tax basic because taxes are really important here in terms of planning. We'll talk about some strategies under lifetime gifting, a little bit about life insurance and its role in planning, and we'll talk a little bit about trust planning. So all of these subjects at the bottom, we're going to be discussing them in some format tonight. If you have any questions at some point, please feel free to chime in the chat and give it to us, okay? So tonight we're going to be mainly discussing these topics for you all, okay? Last will and testament, trust or living trust. Trust or living trust are the same thing, okay? So a trust can be a living trust if it's created during your life. If it's created after, it's a testamentary trust, or it's some other type of trust, okay? But during your life, it's called a living trust. We'll talk about tax planning and gift planning today. So these are the transfer of wealth strategies that we're going to be talking about today. So planning for legacy. And when I talk about legacy, I'm talking about just more than just the physical things that you've accumulated during life, right? So if you are a peaceful person, you want to see family harmony, you want to ensure that the next generation understands the values and the morals and the guidance that you provided during this life, planning takes part into it, right? And most of the time we're planning generally at the beginning, at the forefront, with the will or a last will and testament, okay? In the US, it's a cornerstone of a estate plan. Even if you have a trust, you have a will. And the reason is, while a trust is a contract, a will also is, when you have a trust and you have a will, the trust is like a best practice. I always use the example, if you have your assets distributing by trust, but then you fail to either fund the trust, or you win the $1 million and then you die the next day and the assets are not in trust. How do we ensure that they transfer in the same way that you want as part of your legacy? So if you have a trust, you have a will. All planning generally will have a will, okay? A last will and testament is the cornerstone. There are different types of will. There's pour over will, right? So there can be different types of will, but it really identifies who the person is that is going to be managing your estate after life, right? That's called the personal representative or the executor of your estate. If you have minor children, you can do some planning by will, by appointing a guardian, right? I always use the example, if there's mom and dad, one person passes, the other person is the natural parent. But if that second person passes, right, then who's going to have the children come live with them? And then with children come responsibilities and finances. Who's gonna be the person that's gonna be managing their assets, so the trustee? So will allow you to do all of that, okay? A trust, totally different than a will. A trust is a contract. It's a contract that provides, that can allow for the disposition and distribution of your asset, okay? It can allow for the professional management of assets or for families to manage it. There are different types of trust, okay? We're not gonna be able to get into that tonight, but I'll just tell you, generally speaking, okay? Generally, top 5 reasons that people have a trust, okay? 1, we need to do tax planning. 2, they have minor children. If you have minor children, for most people, they don't want them to get the $3 million at 18, which in a will, they would get it at 18, right? So they want to do some staggered distribution. 3, you have properties in different states. So that's another reason to do trust planning. 4, you are beyond the exemption, the taxable exemption limit, right? So that's another reason to do trust. And 5, you're providing for disabled adults or children in your planning. So those are generally the reason that we are doing trust planning, okay? And then most people have heard about revocable versus irrevocable trust. Revocable meaning amendable, I can revoke it, I can amend it, I can change it. Or irrevocable, it doesn't mean that you cannot change it, but it's just harder, right? It's meant to be a transfer that lasts into, whether that's 21 years or a lifetime, but it's meant to take the assets out of your name and put it in the trust in a separate bucket, okay? So different ways of planning, but certainly very effective. Vanessa?
Okay, yeah, thank you. So, so I'm gonna go over the same concepts that Regine just presented on the Haitian law perspective. So we don't have the same mechanism. So the trust is not, we don't have that legal figure in Haiti. There are other ways, other alternatives that we'll be able to see after that could be used in terms of asset management for the future and after death. So the will is exactly the same definition as Regine gave you. It's a legal document through which a person expresses their last wishes for the distribution of their assets. In Haiti, we have different types of wills, and a person will decide on these types of wills depending on the situation and the context. So we have what we called a holographic will, testament holograph, which is entirely handwritten by the testator. Very often is done in that, sometimes it's done in that way. It's not the best way to do it, but it's done when the person might be in their deathbed or sick and are not able to go to a notary, and they'll do it that way. We have what we call a notarial or a public will, which is done before a notary in front of witnesses. And there's also what we call a secret testament, which is sometimes has certain difficulties to implement, but it's secret. The person writes their last wishes on a paper. There's no specific format for it. It's sealed and it's given to a notary who will keep it until it's time to open it. So it's extremely important to be aware of these different type of wills and have an attorney or a notary advise on the type of will that is more appropriate depending on the situation. So I think on the next slides, we'll be able to I'll talk about the different alternatives that could be comparable to a trust since we don't have that figure in Haiti. Tu peux continuer, Regine? You want me to?
Non, je pense que je suis allée trop loin. So
Yeah,
one of the
you
things I
skipped
wanted-
a slide.
Yes, one of the things I wanted to touch on Vanessa's slide, yes. One of the aspects that's really, different is in IT, you cannot, it says on your slide, you cannot disinherit a child. In the US, you can disinherit children. I mean, it might not be the best thing, in terms of, what that's gonna create, but people disinherit people for different reasons. Sometimes, children for different reasons. Sometimes it's a child that has too much money, and so an inheritance, and if it's gonna create an income, issue for the child may not be the way that they wanna do it, right? Perhaps they decided to gift during the life and in exchange for giving at death, right? So just some critical differences. And then I also saw on your slide that a
Yes,
spouse,
I'll mention something about
the child,
not being able to disinherit a child, since it's comes from civil law, of course. And regarding that, it is actually it's mandatory to not only you cannot disinherit a child, but it is required by law and it's automatic to keep a certain portion for that child. So the law specifies the amount, the percentage that must be kept. So if you, let's say you would give or you would gift, or in a will you would give to third parties that are not your children's. So by law, these children are able to require for these assets to be returned to them because of that legal disposition. So that's what we called in French, la quotité disponible. So there's a specific amount that's dedicated and that must be remain for the child.
and that's very interesting, Vanessa, because while we can disinherit children in the US, we cannot disinherit spouses. And what I mean by that is if we're planning as a married couple, let's say there's half of the couple comes to me, the husband or the wife, and they want to disinherit their spouse, the legal advice that I have to say to that person is, if you disinherit your spouse can elect, it's an election, so they can choose to do nothing, but the spouse can elect against the estate. And in Maryland and in Florida, it's an enhanced, so it's everything, including things that are transferred on death by designation or beneficiary. And that spouse can elect up to 33%. So a third. So if you decided you had 2 children and you want to just give 50% to each of the children, the spouse can come in, if they're married at the time of death, come in and take their 1/3. So now the children's share is smaller. Yeah, so it's just very interesting how the laws are different. But this is why planning with a professional is important, because there are going to be different sets of laws in different places. Okay. All right, so we're gonna move on to financing, management of your finances. In the US, we manage it under a power of attorney. A power of attorney is a document in which the principal, the person creating the document, gives the agent or attorney in fact the authority to act for him or her, generally in a financial capacity, okay? The power of attorneys can be limited, so sometimes you see it in real estate transactions. I couldn't come to the closing. I use a limited power of attorney. That can also be used in planning, right? Sometimes the power of attorney can be general, which means that I can have somebody act for me so long as I have capacity. So it would be the example of I'm in Europe, Bank of America stops my card. I have a general one that allows banking, so the person can go to the bank for me, but I'm capacitated and the person is acting on my behalf. Or the third power of attorney is the durable power of attorney, which is most often used in planning because we're planning for incapacity. So that one, durable, means beyond incapacity. So we can use a document while the person is well, or we can use a document when the person is no longer well, okay? And so very important document for the management of your assets. Super critical that a lot of attention is paid on this document because they can be super broad. You can give somebody a lot of powers to do anything from selling your house, getting a loan on your behalf, all of these things, accruing debt in your name. So it's really important that you understand the document and that you are making these choices willingly. The alternative, if you don't have such a document, would be guardianship. The court intervenes in order to appoint somebody for you. That process is costly, it's timely, the decision is generally not yours, right? And then there are limitations as to that, okay? So I don't recommend a guardianship, but sometimes we have had to apply for guardianship when people don't plan proactively, okay? And then the other tools, we'll talk about these a little bit, joint ownership. So sometimes people will say, Regine, can I add so-and-so to my bank account so that he or she can manage it for me? It's a case-by-case basis. Joint ownership of assets are not always great because if the person decides to take all of your money, now you're out of all of your money. You can't go back to the bank and say, I only added them for this versus that, right? And then the other way that you can manage is beneficiary designation. A lot of you are familiar with that in terms of retirement accounts or life insurance. You can designate someone in order for them to take on the property or receive the property upon your passing. Anissa?
Yeah, okay. So in Haiti, I'll say the definition is the same for the power of attorney, where you select someone to act on your behalf. And that person can have, just like Regine said, a large or a narrow range of operations or actions that can do on your behalf. So it's extremely important to draft it correctly. If you're in the United States and you're appointing someone to act on your behalf in Haiti, it is we call it mandat ou procuration. It has to be legalized. It's recommended for it to be done it's required to be done at the Haitian consulate of your place of residency in the United States, and then it will be legalized in Haiti. We don't have specific titles or specific types of power of attorneys. It just it can be for one mission. Would say, let's say you need to sell an asset in Haiti, so you can appoint someone specifically for that. Donc, it would be a procuration spéciale for that. And if it's large enough, it could be for the person to act on your behalf for anything ranging from financial transactions, interaction with a bank or a sale or medical decisions. We have other options as well in Haiti that will depend on the situation. We have what we call la tutelle, which is similar to guardianship, but it's not as, it's not a complicated, it's not a judicial process as in the US. So la tutelle is also, it's appointing someone to act on your behalf. It's usually used for minors, or it could be also used for adults that are incapacitated in some way. And it's usually done through a council. They call it Conseil de Famille. So any person that has an interest, it could be a family member, it could be, I can't remember. How do you say créancier? A person that
Creditors.
créancier, a creditor, yeah, it could be a creditor that has an interest. They could request that a conseil de famille, a family council is established to manage your assets because they have an interest. La curatelle is also similar. It's in case of medical or déficit mental discapacities, in that case, also, they can, as long as there's a medical diagnosis and certain documents that are provided, a person could act on your behalf or a family member and to take care of your assets and take decisions on your behalf. We also have what's called a conseil judiciaire, and in that case, it's a court-ordered person that will be appointed to help administer. Okay, so in that case, it's less invasive, I would say, entre parenthèses. That person is there to advise, not to take decisions on your behalf. But if you're, let's say, an older person or someone or a very young person that's managing a lot of money or a lot of assets, so the family may require that you have an advisor that's there with you to make sure that the decisions are well taken. So here I'm going to talk a little bit about two mechanisms that are not specifically designed for assets management per se, but that could be used and sometimes are used in Haiti to manage or to plan the management of certain assets. We have a foundation where an asset can be transferred to a legal entity and to ensure management, and where the founders are designating that assets for a charitable mission. Okay, so it's important to note that in such case, it's not there's no benefits for the person, for the founder or their family, unless they're working in said foundation. If it's an organization that's well established, they will receive salaries, for example. But the assets that will be it's like a gift. The asset is gifted for a particular mission, and it will be for a charitable mission. We also have corporations that are similar to the ones in the United States. So in that case, it would be a Société Anonyme that can be used to manage assets through shares. So families often, and it's often recommended, since we don't have the legal figure of trust, where a business is established or properties are put into a corporation and owned and by the family members, where each of them will have their shares. And for example, the founder can retain a majority of shares or have certain rights until their death regarding voting or making certain decisions. So all that can be crafted in the bylaws of the corporation to ensure that the assets are well managed and manage how the founders and the proprietors would want it.
Next, we'll get to healthcare management, right? It's really important that when we're thinking about planning, that we think about what happens if you're alive but unable to make decisions for yourself. Every day, somebody needs that, okay? And every day we get the calls where I'm gonna have a surgery in 2 days. Mom had a fall and now she's a little bit disoriented and I can't make decisions. Technically, under certain state laws, there may be surrogacy laws. But I'll say to you that as a attorney that used to do medical malpractice defense work, sometimes hospitals and doctors are just not comfortable with that, right? Because sometimes there are disagreements among family members about what to do in terms of the healthcare. So they'd prefer to have the document in which the principal determines what he or she would like and who he or she would trust to make those decisions. One, from a liability perspective, but two, from a clarity perspective. The document may be called different things in different states. Sometimes it's a advanced medical directive. Sometimes it's a medical directive. Sometimes it's a healthcare designation or healthcare proxy. Whatever it's called, wherever it is, it does the same thing, okay? It's a document that tells you who your agent is to make healthcare decisions. So that person is going to be able to authorize treatment, stop treatment, talk to your physician. They'll have all the HIPAA privileges, so they'll get access to your medical information. They can ride with you in an ambulance. That was a COVID provision, right? If you remember back in the day, during COVID, you couldn't ride with people to the hospital or to visit them at the hospital in case of a pandemic, which we had a few years ago. So super important in terms of making sure that your wishes are honored, at least as it relates to the dignity of your body and your personhood, is a medical directive. Subsequent to that document, or also with that document, I should say, is a living will, not to be confused with the last will and testament. A living will specifies what you want to happen in the worst case scenario. Worst case scenarios are death is imminent regardless of how much treatment they're going to give you. And based on people's religions, family values, personal goals, that differs. Some people are like, please don't keep me alive for more than this. Some people are like, keep me alive at all costs, right? Give me blood transfusion, don't give me blood transfusion. Give me this type of medicine, but not that type of treatment, right? Whatever it is, you can articulate that in a living will. Certainly, you can't foresee everything, but to the extent that there are certain things that are important to you that you want to ensure that are happening or not happening, this is a really good document to have. I do understand that sometimes some people don't want to have the living will because they feel like they're kind of like playing God. And so certainly, if you want to just have the directive that appoints the agent, you can do that. But, generally it's advisable to have both. If you don't, the court has like I said, the court has a plan. And the plan with the court is guardianship. I've been involved in situations where treatment was delayed because the person could not articulate it, the doctor was uncomfortable. And so, whether that be cataract surgery, heart surgery, any kind of treatment that they feel like they really would like to know either what the person's actual wishes are or what the court will allow them to do through guardianship is what is going to happen. Okay. I will say guardianship is not the best option. The courts are limited. For example, I've served as someone's guardian and they were in health peril, if you want to call it that. There was a hospital transport and the person was super frail. And I got the call and the call was, we have to move her from this place to this place, but we're concerned that she may not make it. What do you want us to do? And it wasn't what I personally would have wanted for myself. It wasn't what she would have wanted for herself because she didn't have an advance directive or a living will that told us what. It was what the court told me by court order I had to say, right? And by court order, I had to say you have to keep her alive within all reasonable means possible. I'm not sure if that's what the woman would have wanted. I'm not sure if that's what her family wanted, but those were the instructions that I had to give to the hospital personnel. And, even as a person that's making guardianship decisions by court order, that's very hard because I believe in the dignity of people. And I'm not sure that's what this woman would have wanted. If that's what she wants, I'm at peace. But I don't know. And still today, I'll never know, right? So it's really important that if there are decisions that are important to you in terms of caring for yourself and treatment, that you make those decisions yourself.
Okay. I think I went over these mechanisms earlier, and these are also used for medical reasons. So I spoke about them regarding financial decisions and transactions, but they are also used for medical representation. So I'll go over it again a little bit. Like I said, interdiction, I'm using another term that's also used for it, which is similar to the curatelle. L'interdiction is when if the person, it's ordered by a court, if the person is legally incapable to the medical illness, then that person can receive, there could be a court order deciding on a guardian who will be appointed to take decisions. So that will also include medical decisions, similar to the ones that Regine just stated. It is not very common, I'd say, in Haiti, and I've rarely came across these types of cases where decisions had to be made in such capacity. But it is possible. And it's same for the tutelle, which is in this case is not just one person, but it's a council of family councils that will be taking those decisions. And the Conseil judiciaire, in that case, the Conseil judiciaire is specifically for financial decision, but not for medical reasons.
All right, I'm gonna talk a little bit about basics for planning. It's not meant to be a full tax class. Obviously, taxes are super important in the area of estate planning. One of the first things I do before I even get to planning is I need to know what your assets are, because I need to know how they're gonna be taxed. Whether there's an income tax, an estate tax, a gift tax, is important to me, in terms of planning, because I need to see the whole picture. So taxes, super important, but I'll tell you in terms of, you know, what the taxes are that you may encounter when you are planning. Federal gift tax. So the federal law says that you have an exemption, okay, or an exclusion amount. So up to a certain amount of money, and then after that, you're taxed at 40%, okay? Currently, we have, I guess currently until next year, we have one of the highest exclusions or exemptions amount. It's $13.99 million in assets, and next year is going to go up to 15 million indexed for inflation. So we have one of the largest federal gift tax exemptions currently. Most people are not over that, but I do planning sometimes that people are over that. And so when you're over the 13.99 each person, then we have to think about how do we minimize the taxes. Doesn't mean that I'm going to be able to erase it, but you know, sometimes, you know, let's say you have a $6 million projected tax bill, and through planning, I'm able to get to 1.2 million. That's an additional 4 million that's going to go to your family. So that's well worth it in terms of planning. Okay. I did federal estate tax first. Federal gift tax. Gift tax. Annually, you are entitled to give to each person a certain amount of money. Currently, it's $19,000 per year, okay? So what that means is if I want to give to Gilles $19,000 per year, I can. Then if I want to give to Vanessa $19,000 per year, I can. And in that same year, I can give to Gilles, to Vanessa, to Joelle, and to somebody else, right? Each person can receive $19,000 per year from me, right? If I go over this 19 by a penny, what needs to happen is I have to report it. I have to report to the government that I made a gift over that amount, right? It doesn't necessarily mean that I have to pay taxes, okay? Because you get a lifetime amount as well, right? But for some people, gifting is a really complicated area of the law that we use in order to reduce people's taxable estate. Because if you gift during life, it's not in your estate at death, right? And so for some families, that's one way for us to get around it, so that we can get the money from the highest tax earner to the children and grandchildren as a gifting mechanism, so we can take it out of their estate, okay? Federal GST. GST is generation skipping transfer tax. And so it's a tax that's imposed when you decide to make a gift and skip a generation, okay? It's a very complicated process. Obviously, when we're doing planning and you're telling us that you want to give to your cousin that's 9 years old and you are in your 80s, then I'm going to figure out whether there's a GST implication here. And so if there is, then I have to, make sure that your plan does not implicate the GST tax, because it's 40%. That's a lot of money during life, okay? Also, you are taxed on top of that, or you're taxed on the tax, which is quite interesting. And then inheritance tax, only 9 places in the United States have an inheritance tax. It's for the benefit of receiving. Maryland, which is where I am today, has a Maryland inheritance tax. So Maryland says that you can give to direct lineal descendants, but let's say I wanted to give a gift, I wanted to give something to Gilles in my will, and Gilles and I are not related, and he's not my direct lineal descendant, then Gilles would have to pay a tax for the benefit of receiving that gift. So when we're talking about planning, those are the taxes that we're thinking about in addition to income tax. Income tax comes up a lot more than people think about it. Let's say you have an asset. I'm gonna give an example. You have a rental property that's part of your estate. Person dies, they have a rental property. Every month, the tenants at the rental property are paying $1,000 in rent. That's rental income to the estate. You get a $600 exemption, right? So anything above $600 has to count as income after life. So income tax also comes into it. So these are all the things that we have to think about when we're planning. And what assets are going to make are potentially exposing you to gift tax, inheritance tax, estate tax, income tax, and figuring out the whole plan.
Okay, so in Haiti, first I have to mention that there's no double imposition treaty between the United States and Haiti. So if you're a Haitian American and you're receiving some type of income in Haiti, you will pay taxes in both countries. Regarding the transfer of assets, we have what we call le droit de mutation. It's a tax on the transfer of assets. The amount, the percentage will vary depending on the type of transaction. Let's say if it's between a spouse to another spouse, it will be a percentage. If it's from a father to their child, it's another percentage. If it's a general transaction between, like, say, for a sale. And so the percentage usually varies between 1 to 3% of the amount of the value of the asset. We don't have so income tax. So if you receive if you're the beneficiary of an asset in Haiti, so you have to keep that in mind. And if you're using any type of mechanism to manage your assets, just like I said, for example, a Société Anonyme, a corporation, you have to keep in mind that when you're going to receive your share, when there's going to be distribution, you will have to pay from that income in Haiti and in the United States as well. We have, it was mentioned here, what you call the caution. We call it caution judicatum solvi. It is not per se a tax, but it is like a guarantee. It's a security deposit for foreigners. If you're going to be part of a judicial process in Haiti and you're a foreigner, so it is required by law that you make a security deposit to ensure that you'll be able to pay for the cost of the proceedings or the damages that would be ordered in case you would lose. So in the case of Haitian Americans, this no longer applies since in 2002 there was a law, and that was confirmed also by the amendment that was done in the Constitution, where foreigners that have Haitian origins are treated equally, and they will not anything that is imposed to foreigners will not be imposed to Haitian Americans. Except, of course, voting and being able to present themselves as a candidate for elections. So basically, I think that's it for regarding taxation in Haiti. So as Regine said, it's important to get legal and professional advice for that, and make sure that you find the best possible way to have an maximize or have a efficace way. How do you say that in English? I keep forgetting. I'm mixing the languages.
You're doing well. Efficiently. Yes, you're doing great.
For the management of those taxes.
Yeah, absolutely.
Hmm?
All right, we're gonna get right to lifetime gifts. I love lifetime gifts, okay? And when we're talking about gifting, it's not gifting of the, $5, $10, $15. We're talking about gifting as a strategy, long-term strategy. If I'm projected to have $42 million at death, and I think that I'm gonna be in a taxable bracket, right? And so my 42 million is probably gonna yield, $6 to $7 million in federal estate tax, right? Of course, I understand that inflation and all of the things play into it. Perhaps I use more money when I'm older versus now, or I have a lot of income producing assets, right? How do I get rid of this 6 million? I'm either going to give it to charity, that's always a good thing, or I'm going to give it to the people that I want to have it. And why do I want to gift? I want to gift because I need to take it out of my name. I need to disassociate myself from the asset, which means I need to give up control of the assets. One way we can do that sometimes is through irrevocable planning, irrevocable trust planning, but it's a really good way to do that. It needs to be a strategy, okay? This is not, oh, Regine tells you your projections and you just start gifting money away. It needs to be part of a strategy. We do gifting as a strategy. So this year you're giving $1 million, next year you're giving $1 million. And sometimes the $1 million you're giving is just interest, not principal, right? But we are making it, we're doing it to minimize transfer taxes by taking advantage of, either the annual gift tax exclusion, which I said is $19,000 per year right now, or to give more than that, but with the understanding is that these assets are going to go to the generation that you would have wanted to go to at death, okay? And when I say it's a strategy, because there are advantages and disadvantages in gifting, right? But in every situation, we look at what is the advantage in gifting, what is the disadvantage in gifting. I'll give you one example of disadvantage. I always give this example. It's a silly example. If I have a pencil, the pencil is, I pay 50 cents for this pencil, right? So that's my basis in this pencil. If I gift this pencil to Gilles today, Gilles takes it subject to my basis. So Gilles' basis in this pencil is 50 cents. In 15 years, when he sells that pencil and it's worth $100, he's gonna have to pay capital gains from 100 minus 50, okay? Instead, I hold on to this pencil, but now I don't have this 50 cents pencil that appreciated in my estate at death, right? But the other alternative is I hold on to that pencil until I die. Now this pencil at my death is worth 100, and the pencil is still gonna go to Gilles. At my death, the pencil is worth $100. So Gilles gets the pencil subject to my step up in basis. So sometimes we have to play with these tax things when we're gifting, right? Tax methodologies, I should say, in gifting to see what example is going to be best for the client in the long term as part of their estate. Because my goal is obviously I want to diminish the risk of litigation. I want a clear plan. I want to try to protect you from the taxes as possible. I cannot promise to eliminate it, but if I can buffer it in any way, I will. I will do it in accordance with the rules that are written here. Okay. And then we want to thank you. So, Vanessa, anything else you want to add in terms of gifting? Is there a similar concept?
Well, it's not the same in Haiti. You can decide to give, but I'd say for tax purposes, sometimes if you're in the trying to manage the assets and looking for an efficient way to manage them, very often donations are not the way to go because they're very highly taxed. But it's definitely another mechanism that can be used if you want to ensure to provide for a child or a loved one or third party. It doesn't have to be a family member. So donations are of course regulated by law, and they have to be done before a notary. So if it's in the case of real property, and so I say an acte authentique, so it has to be notarized. And like I said, very often it's worth it to evaluate it to see regarding the taxes that could be paid for those donations depending on the value of the asset.
And at this time, we'll take any questions that there may be.
Yep. So, we do have a couple of questions
Yay.
from the attendees. First thing I will say before getting to the question, anyone who is part of the session is being recorded. It will be made available on AHP's YouTube channel right at the end of the session. So with that said, the first question is as follows. 1 second. Check. So, regarding not being able to disinherit a child in Haiti, I would like to confirm that this applies to all children within and outside of marriage. Is that right?
Yes.
Vanice,
Yes, that is correct. The law in Haiti no longer differentiates between children born in outside of marriage and we still have the denomination that says enfant légitime et enfant naturel, but both have the same rights regarding inheritance.
Thank you. The next question is there a statute of limitations in Haiti for a child to make a claim as a beneficiary?
Okay, so it will be the general statute of limitation. So the longest one, which would be 20 years. Of course, it could be, there's different, like if you're talking about if there was someone managing your assets, a guardian, or conseil de famille, for example, there's a shorter statute of limitation. I think it's 2 years. I'll have to verify that. I'll send you the answer, but it's 2 years if there was mismanagement regarding those assets. But if you want to claim an asset, or if you weren't part of succession, droit successoral or partage, that is it's a general statute of limitations, the biggest one.
Thank you, thank you. And one last question, again, it pertains to the Haitian jurisdiction as it relates to the topic. Is there a Haitian equivalent to a probate court? Is there a specific government agency that handles probate matters that may be in dispute?
No, in Haiti, we don't have a specific jurisdiction. For that, it will be the civil court that will handle the matter.
Thank you.
all right. Well, is that all the questions we have?
That's all the questions we have in the chat. I don't know if anyone on the call, we can open the floor. We have a few minutes. If anybody wants to ask a question of our esteemed attorneys here.
Well, no pressure. We do want to thank you all for joining us this evening. We want to thank the Association of Haitian Professionals for having us here. Vanessa's information is on the chat in the slide, and my information is in the slide as well. If you have further questions, feel free to reach out to us if we're able to assist you.
Thank you,
Thank you,
Regine,
everyone.
Vanessa, for your support in answering the questions having to do with this topic of interest. It is our appreciation for your presence and your sharing your knowledge and educate our audience. We know this topic, sometimes people feel it's touchy, but I know it's worthwhile to bring it to the audience so everybody's aware and educated and make the best of it. And again, Regine is in the US, Vanessa is in Haiti. We know we have Haitians who have assets in Haiti, assets in the US, so we wanted to make sure that is available for our audience to take most benefit of it. Please support our attorneys. They're here for you. And thank you for participating in this session. Until next time, thank you.
Thank you. Thank you, Vanessa, for taking my
Thank you.